Welcome to David and David on Real Estate. Join us as we explore the ins and outs of the real estate market.
Hello, David, and welcome to podcast number 4. Super excited to have you joining us today.
And hello, David. It's always great to be with you. And looking forward to continuing our discussion from last week, because we didn't get half the things on our list that we thought we would put in last week's podcast covered. So we're going to continue today. So I've been looking forward to it all week.
Oh my God. I remember when we started first started talking about doing a podcast together, we were thinking, how are we going to fill an hour of time? Right. Yeah. And meanwhile, when you're this passionate about real estate, it gets really easy to do that.
Yeah, and there's always stuff changing. There's always things happening, and it's a moving target. So there's always something new to discuss. So we should probably get right to it. Are you going to give us a little bit of a market update to what's happened in the last year?
I would absolutely love to. And listen, May the 4th was a big day because the Toronto Real Estate Board released their April numbers. And what the board does is they do a month-over-month comparison. So what they do is they compare April 2021 and use April 2020 as a baseline. Now, David, I don't know if you remember a year ago, April 2020 were the first few weeks of when the pandemic actually started. So the numbers for April 2021, as released by the Toronto Real Estate Board, are extremely deceptive in what they show. Because I think they show something like, I'm just looking here, April 2021, 13,663 sales. And April of 2020 only had 2,957 sales. So we're seeing a 300 plus increase in the number of sales activity as reported by the Toronto Real Estate Board. So I can only imagine what the 6 o'clock news is going to do with this information and the headlines we're going to see all over the news today. But I want to caution everybody and realtors in how they portray this information to the market and to their clients, because I think we have to really dig deep and uncover the layers and really understand what these numbers mean, instead of just blindly saying that, hey, we're seeing a 367% increase in sales activity month over month from last year. It would be incredibly not the right way of portraying these numbers.
I agree with you 100%. That's incredibly deceiving. It would probably make more sense for the comparison to be to 2019 numbers, because there's no question that last April would have had higher numbers if we didn't get hit with a pandemic. We've never experienced a pandemic like that, and it was hitting everybody March, and then the total shutdown came down, and we were just finding out later in April, of whether or not real estate was still going to be an essential service and stay open. We thought we might all be shut down. So no one was out there putting their homes on the market and everything for a few weeks. And that's what these numbers clearly reflect that. So you can't look at these and say, oh, there's a 300% increase, because it's always compared to what? And you're comparing it to an April in a pandemic that we've never had before. So we know every year the market heats up as we get into the spring, and February's better than January, and March is better than February, and April's busier than March. And that happens every year in every market, no matter what, because we're very cyclical, especially, we're talking residential real estate. Last year, the same thing was starting to happen until we got hit with the pandemic. So good news is, the activities started to go again after April. Things started, I think we'll have that when you see the May numbers that we'll look at in a few weeks. But, this year it happens to be a very strong market too. I think if you compared it to a 2019, 2018, the April numbers, I think, would still look really strong.
Yeah, and I think what would be helpful is to look at the 10-year sales average, right? And the 10-year sales average is about 10,000 units in April. So when you look at April 2010, 2011, all the way to April of 2019, the average number is about 10,000 units. So when we compare, 13,663 units sold compared to the 10-year average of 10,000 units, now we're seeing about a 36% increase in sales activity in April of 2021, which, given the fact that we are still in the midst of the pandemic with the stay-at-home order, I mean, it's just tremendous amount of sales activity out there.
No, it is. And I always tell every agent that I speak to, if you're not busy right now, you got to get out there. Like, there's stuff going on, and people are, want to move. They want to make changes. There is a little more supply coming on the market, which will help with some of the multi-offer stuff. But everybody should be out there because there's people that are anxious to make changes in their lives. And that sounds like a much more realistic number when you talk about a 35% increase, because there's no question that that it's been a good market this spring, in the early spring, like February, March, April. It's been a very strong market in any year.
Yeah, absolutely. When you look at the number of new listings coming onto the market, again, huge increases in percentages from April of last year. But when you look at the 10-year average, we're only seeing about 18.3% increase, which, again, I mean, given the fact that it's a very strong seller's market and people want to take advantage, 18.3% seems like a reasonable increase as well.
Yeah. Yeah, I know we're certainly feeling it in our office, in terms of the closings, and we always lag behind the sales by a couple months, 6 weeks to a couple months. But our volume every month this year has been very strong compared to, not last year. Like, it blows away last year, because these were the early pandemic months. But to prior years, we're way ahead of prior years in terms of the volume of closings that we're handling.
Yeah, I'm just going to read you a line here from Jason Mercer. He's the Toronto Real Estate Board Chief Market Analyst. Despite a modest slowing in market activity in April compared to March, selling prices for all major home types remained very high. Low borrowing costs associated with COVID-19 clearly had an impact on demand for and price of ownership housing. While the pace of price growth could moderate in the coming months, home prices will likely continue on the upward trend. Renewed population growth over the next year, coupled with a persistent lack of new inventory, will underpin home price appreciation.
Well, that sounds like fair comment, and it's consistent with what you were telling me last week when we did this podcast about that. You were sensing a bit of a slowdown in the activity, and there were still multi-offers, but instead of having 16 on a property, you're getting 5 or 6 and things like that, right? And then you couple that with the fact that a little more supply comes on the market as you get into late April, early May, that sort of evens it up. But there's lots of activity, but it might be less of this multi-offer type of activity.
Yeah, and I think the low borrowing costs still remain. Interest rates are still very near historical low levels. Cost of material is going up substantially, right? So a lot of people are getting into the mind frame that, hey, you know what? Let's buy a new house instead of renovating our old one, because it just makes financial sense to go that route as well. And then with the stay-at-home order, a lot of people are hesitant to list their house on the market and have people visit and have that exposure and go through those roadblocks. So we are seeing the market sort of balance between supply and demand, the low borrowing costs, and kind of adjust to what's really happening out there.
Yeah, and that's a great point, David. Like, the renovation costs are sky high right now. Certain materials like lumber, you can't, the price of a 2x4 has gone up by a lot in the last little while. You can't get it. And you can't find a renovator or a contractor to come and work on something or to fix a problem. So those are issues as well.
Yeah. I came across a meme on Instagram the other day where a piece of plywood went through somebody's windshield, and there was a caption that said, "You know what? I'm going to sell the piece of plywood and buy a new car."
Yeah, that's good.
All right, so let's get into this, Dave. We were really talking a lot on podcast number 3 about really what happens when a transaction doesn't close, right?
Yeah.
What are
Yeah.
the obligations of the buyer? What remedies does the seller have? Can you take us through what normally happens when the closing date comes and one of the parties is not ready to close the transaction?
Yeah. Well, most of the time this happens on the buyer's end. It's, most of the time it's the buyer that can't close. The seller can generally close, unless they get cold feet, which we talked about last week, and they don't have a right to get cold feet because they think there's a better offer coming or something like that. So most of the time it's on the buyer's side that they have an inability to close. And then it depends on why they can't close. And a lot of the time it's because of the financing. They can't get their financing, or they can't get their financing in time, or they can't get enough financing. So those are generally, the reasons that prevent a buyer from closing. So we have to look at each one. And if a buyer can't close because they have a timing issue, because they just can't meet that time is of the essence that we talked about. They have to close on the closing date. They need a few more days. They need a week, or their commitment fell through because they were still underwriting conditions and they thought they had everything in place, and all of a sudden we're almost at the closing date and now they can't get it, and they've got to go to another lender, or a schedule, instead of an A lender, they got to go to a B lender or a private lender, and they need time. So then they're asking for an extension. Okay. So a seller doesn't have an obligation to give an extension. It's something that has to be negotiated. So generally, if I'm on the seller side, I want the buyer's lawyer to send me a letter saying, we can't close on May 5th, our closing date. We need an extension for a week or 2 weeks. Here's why. And is your client in agreement to that? And then I can reply back. I can speak to the client and see, because most often we would want to extend if we think it's real. Okay. And if they need a couple days, or they need a week, or a reasonable time period, we would like to cooperate and extend, and we would impose certain conditions on them. So the approach that we take is I would write back to the lawyer saying, you've notified us that you can't close. So that's an anticipatory breach of your agreement of purchase and sale. So we reserve our rights, to keep the deposit and sue you for damages and all that stuff. But without prejudice to those rights, we're prepared to extend on the following terms and conditions. And then we'll list what those terms and conditions are. And we might want evidence that they have a new commitment or an ability to get financing. We for sure want them to pay the costs of the seller for that time period to make sure they keep the seller whole, because the seller won't have that money. So they should give them interest on the money, or interest on their, cover their mortgage costs, their utility costs, their insurance costs, the extra legal costs for negotiating that type of thing, to keep them whole. But generally we take an approach, we try and extend if on reasonable terms if we can, because it's generally better for the seller to do that than go back to the market and just rely on their strict rights and say, oh, I'm keeping your deposit, I'm going to sell it to somebody else. In certain circumstances, we'll take that position because they have the right to do that. But we have to look, is that practical? Because by the time you put it back in the market, is the market going up? Is the market going down? How much time is going to go by until you close? So you got to weigh all that. So
a lot of the times the houses are not prepared anymore. The staging furniture is not
Right.
there.
All been
There's boxes. The walls were scuffed when they were removing the big couch, right? So the house is definitely not market ready at that point.
Right. And you'd have to start that process over again, and not knowing, what's the market you're going to get into a week or two from now. Are you going to sell for a higher price, a lower price? How long is it going to take? Is it going to, can you get a closing date that's quick, or is it a closing date? If you sell it tomorrow, they can't close for another 2 months. So now that seller's stuck. And it also depends on what the seller is doing too, because the seller needs that money to buy another property. That has to be factored in as well. Or does the seller have an ability to get a bridge loan in the meantime? So they got to carry 2 properties. So we got to factor all those things in. So we're not always just hammering the other side with our legal rights. We have to look at the practicalities, because our focus is always, how do we get this transaction closed? How do we, it doesn't serve anybody to not close or find a way to close. Seller needs their money. We want the agents to get their commission. We want everybody to move on to the next thing. So we try and look at it from that. So we have to understand what the seller's position is. And we also want to see, is the buyer bona fide? Like, do they have an ability to close in a week when they tell us they're going? Is there a mortgage commitment? We want to see the mortgage commitment at some point. But we're generally going to give them some leeway or negotiate some leeway, even if we don't have mortgage commitment, but we expect to get one in the next week. Okay, we're going to extend for a week on the basis that you produce that mortgage commitment by the end of that time, or we'll terminate you at that point in time, right? So we want to play ball as much as we can, because we want to be practical, but we have to make sure we protect the legal rights of the seller at the same time. So the position that in our office that we take, and our lawyers all do it, is we like to write back saying, you're in default, you're in breach, we have certain rights, we can scoop your deposit, we can sue you for damages, but we're not, without prejudice to those rights, we're not going to do it, and we'll extend on these terms and conditions and give you some time. And then when we get to the end of that extension period, we have to assess, if they can close, great. If they can't, they need a further extension, we may have to negotiate again, or we can always pull the plug at that point in time and keep the deposit and sue for damages and put it back on the market.
What a lot of people don't realize is how much market forces play a role in those negotiation tactics, right? Or not tactics, but approaches that the seller takes and the legal office takes, right? Because, like, for example, if it was a strong buyer's market, the situation would be reverse. And yes, the seller would have some legal rights to keep the deposit and to do certain things and to be compensated for certain damages. But at the same time, you'd want to take a completely different approach, because protecting the integrity of the deal would be absolute paramount in those situations. You don't want to go out to the market, look for another buyer. You want to make sure that you're working with what's at hand, right? But if the market's really strong, like the market that we've had, and I think we talked about a very specific example in the last podcast, but literally the difference between 24 hours can be hundreds of thousands of dollars towards the seller, right? If you navigate and time this market properly. So, very different approaches. And, I know a lot of sellers were looking for those anticipatory breaches to come, right? Because they knew that, in 3 months, they could have gotten more than they did previously for the property. So the market conditions certainly play a huge factor in how some of those conversations go.
Yeah, and that's a great point. And the market conditions play a huge factor in the legal advice that we provide to clients on this, which is why I have to stay in touch with you and get the market updates and try and understand what's going on in the market as well, because it changes my approach and how I'm going to deal with this. In different market conditions, sometimes we would have, it's not really the buyer that's defaulting, it's maybe the seller hasn't fulfilled everything under the agreement. Maybe there was an inspection and there was 20 things that the seller then on amendment agreed to repair and replace and fix before closing. And then you get into issues of, they haven't done it and we're now at closing, or they haven't finished it all, they haven't done it properly. So the buyer hasn't done anything wrong yet, but the seller can't really fulfill their obligation. So then what does the buyer do in that situation? Do they try and terminate the transaction? Do they try and close with an abatement in the purchase price? Do they extend the transaction to give the seller more time to fix it? So a year ago, 2 years ago, when we're talking about those issues, we had a lot of that. Markets were different. And the seller was, okay, don't terminate me. I'll do what I got to do and I'll fix it, because they don't know where their next sale is going to be, right? Today, we don't even get those lists of items for sellers to fix before closing very often, right? There's no inspections on a lot of these offers. The buyer, you take what you see and the buyer's got to fix it themselves after closing, right? So our approach is different on those things because of market conditions. So that's why as a real estate lawyer, we have to be sensitive to to the market information we get from your brokerage and from hearing from you.
Yeah, working together is so important, right? Just for the benefit of everybody involved, right? It's very much a team approach, and the more open conversation that there is between everybody, um, the better for the clients ultimately.
Right.
So David, what are some of the damages? Like, let's say a buyer doesn't close. What are some of the damages that occur along the way? You spoke about, a lot of the mortgage payments and utility costs and carrying costs. What are some? Give me a list of a couple other damages that might have occurred because of a buyer's decision not to close and follow through on a purchase decision.
Yeah. Well, the biggest one is obviously a difference in purchase price.
Okay.
Because the seller's got to go back and they have an obligation to try and mitigate their damages, which means it's a legal principle, which means that they can't just sit back and take the first price that comes along or the first offer comes along from somebody else, even if it's $100,000 less than what they'd sold it for, and say, okay, so I'm going to sue the defaulting buyer for that money. That's not, the law wouldn't support that position. They have an obligation to put it back on the market in a multiple listing situation and try and get fair market. They have to establish that they made an effort to get fair market value. Otherwise, they're not going to sue for those damages from the defaulting buyer, right? But that's obviously the biggest one, the difference in purchase price. So let's assume they did that and there was a difference in purchase price, because we're not in a market where the prices are going up, but let's say the market stops and they do sell it for $100,000 less. So they can certainly claim that as part of their damages, right? And then there's the timing issue. They were supposed to close on May 5th. Now they sold it. Maybe they put it back in the market, sold it May 6th or 7th, but the closing isn't until July 7th. So now the property is being carried for a couple months. So they've incurred insurance costs, utility costs, property taxes, during that time period. They may have incurred other costs to restage the property or to fix up certain things. They may or may not be recoverable for that, depending on that, but you certainly put it on your list and you might have to argue whether or not that's a reasonable cost that's incurred. The other thing that, that they need to try to recover is their carrying costs of the property. If they were supposed to close today and they're getting all the proceeds and it was $1 million, they'd have $1 million in their bank and they could be earning interest on that money going forward. Instead, they didn't close, they don't have that money, and they still may have mortgages to pay on that property. So they've got those carrying costs of those mortgages. Okay, they may have had to be buying another property, and because they didn't close on their sale, now they have to get a bridge loan, and they're carrying two properties. There's the cost of the bridge loan. So those are the type of things that might be recoverable. A bridge loan, not necessarily would be given to them. It depends on what the defaulting buyer would have known. Like, did they know that this was part of a chain and they needed this closing to buy another property? So it's reasonable to know that they would incur bridge loan costs. So sometimes you might be able to recover that. Sometimes you might not. So you look at every potential cost that they might incur. They may not all be applicable. They may not all be recoverable. But you have to remember too that these are all damages, and these are in addition to just keeping the deposit. Okay.
In addition to.
So the law is basically you default, you lose your deposit. That's gone. And now there's all this.
Doesn't matter how much the deposit is. Like, doesn't matter whether it's $1,000 or $100,000.
Yes. Yeah, it does. Like, the basic principle is that it shouldn't matter. The deposit's just gone. Right. But when these cases do go to litigation, and they are, there's an argument that's made by the defaulting buyer a lot of times, or by their counsel, especially when there's a large deposit and they've sold for a reasonable price or a better price or something, that they argue on equitable principles. Like, this is just too much. Like, why should a seller recover all their damages, all their losses? And then there may have also been a $400,000 deposit on a $2 million home or something, and they get to keep the full $400,000 as well. When they also sold that $2 million home, when they resold it, they sold it for 2.2, right? So at some point, a judge is going to say, on the equities, that's too much. and we're not going to let the seller keep all of that. We're going to make sure the seller is whole, and we're going to let them keep some of that, because otherwise, what's the point of having a deposit? So they're going to allow them to keep some of that deposit, but not necessarily the whole thing, depending on the amount of the deposit in question, right? Otherwise, like, why have deposits? You look at the multi-offer situations we're on right now, and you got 16 parties coming in with offers, and they accept one of them, so the other 15 are all gone. And if that one doesn't make their deposit when they're supposed to, they've now tied up the property. Everybody else has disappeared or moved on, and now they're in default. So what's the point of, if they just off the hook, what's the point of having deposits in the first place? There's supposed to be, a forfeiture of those deposits if there's a default.
That was going to be my next question, is if a property, if a buyer defaults and a property goes to market and they get a higher price, so there really isn't any damages as in disposition costs, right? What happens to the deposit? So it's the balance of equities that plays into a factor then.
Right. Yeah. And the basic principles, deposit should be gone, forfeited. That's the end of it.
And that's common law. That's entrenched into common law.
Yeah, but then there's some equities where the parties can argue that it's not reasonable. It's too much of a windfall for a seller, and it's too punitive on the defaulting buyer. It depending, I mean, a lot, like your point is well taken. It depends on how much the deposit was. If it's a $20,000 deposit, it's one thing. If it's a $400,000 deposit and they sell for a higher price, it's looked at differently, right? So there's definitely a factor there. And the other factor that has to come into play is, even though the parties, establish what their legal rights and principles might be, again, they got to look at the practicalities. The buyer might say, you know what, I know you've got my $100,000 deposit. I'm prepared, even though you're going to sell the property for more, the market's good. I'll cover you for damages, but it's reasonable for me to ask for half of it back, and we can just settle this, and nobody has to sue anybody. And we could just negotiate a settlement. You keep half, and I'll get half back, and everybody can move on. And sometimes that's a good position for a seller to accept, because they'll have that $50,000 when they're in a market and they get advice from David Gorski. They're going to be able to resell it at a higher price, so they know they'll be covered, and they've got enough to cover any damages they really might incur. But now they don't have to be involved in a lawsuit over it, because no one really wants to be in a lawsuit, and it's, I think, from your point of view, from my point of view, it's always good advice to give clients to avoid a lawsuit if they can. If there's a reasonable settlement out there, take it.
Yeah, 100%. I mean, you never want to have your fate decided by a third party. You want to be in complete control of your fate, and best way of doing that is ensuring that there's a meeting of the minds, and both parties agree on a resolution. And that's really where things stop and where things end, right? The worst thing to happen is to go through the court system, which is a very lengthy and expensive procedure. You have to hire a litigation lawyer. These are people who minimum charge couple $100 per hour for their time, and everything that happens in court is lengthy, and there's a process to it, and the judge has to find out all the facts, which takes time. There has to be several court appearances before anything is determined, and you're really giving your faith in the hands of somebody else. So probably the best thing to do is to make sure there's a resolution before that happens, for sure.
Yeah, and litigation takes time. Even pre-COVID, it takes a long time. You're not going to get it through and get a decision of a trial court, without it going at least a year to 2 years going by, and then they're subject to appeal. And the first thing that litigation lawyer is going to ask for is a retainer. Aside from whatever their hourly rate might be, they're going to want a retainer to look at something like this. If they're going to, if they have a lawsuit over $100,000 deposit, they're going to be asking for a minimum of a $10,000 retainer in most cases. And you might be on the right side of this. You might be the seller, with a defaulting buyer, but you still have to lay out that $10,000 to your litigation lawyer, and you hope that everything goes well, and you might be able to recover that or some of it if you're successful at the end of the day. and it's expensive, and that's just to get it started. And then then it keeps going. You got discoveries, you got the whole process, the time lag and everything. So, I always say to clients, are you looking to, to buy a property or buy a lawsuit? You got to look at these things practically when you're involved in this, and cut your losses when you can cut your losses.
Yeah. And you have to ask yourself, listen, how much is your health worth? How much is your time worth? How much is the positive energy in your life worth to you? How much is this negative situation going to drain you? And what's the opportunity cost on the other side of the table, right? Because, sometimes you might not get the favorable outcome that you think you deserve, but it's a lot easier to shake hands and agree to disagree and move on to the next project or next big thing, or look at a different transaction.
Right. And buyers are motivated to try and get whatever they can back from the deposit. They need that money. If they can't close on this property for whatever, then they're going to be looking generally for another property, and they want the money for their next deposit. So, and sellers want to move on and sell and not be tied up in litigation generally. And you as a brokerage, like, I imagine you don't really want that money sitting in your trust account. You want to get releases done when they can be. And maybe we should talk about releases a little bit too, because I know, like, you don't want to release money from your trust account without there being a release by both sides, right?
Correct. So, trust accounts are extremely important, and we take trust money very, very seriously. We actually account for it almost on a daily basis. We go through full reconciliations on a weekly basis. We do monthly reconciliations as well. And in the 35 years that we've been in business, we've never had any issues whatsoever with any trust monies going in. And we regularly hold tens of millions of dollars in our trust account, pending transactions and closings. We are a really busy brokerage, but it's something that's very, very important. And there are very clear rules governing trust accounts and how that money can get deposited and withdrawn from the account.
Right. So if you're told by one of your agents that, my deal's being terminated, and we need the deposit monies released so they can move on, what's your response to them? Like, what is it that you say? Well, I can't send out the trust monies until I receive what?
Well, we need signed written direction from all parties involved, from both the buyer and the seller, and from each of the buyer and each of the seller, before we can touch any trust money. So there has to be a mutual agreement in place, and we call it a mutual release in the case that both parties agree to terminate the transaction and release trust money. We call that document a mutual release, and it's actually signed by not only each party to the transaction, but also the broker of record for the listing brokerage and the broker of record for the cooperating brokerage, because we want to make sure that each party and each management party is also aware of what happened here, why the funds are being released, and the fact that the transaction is no longer being consummated.
Yeah, and the two respective brokerages and the agents involved have an interest themselves in that deposit money, because that's the money that's generally used to pay their commissions. So there has to be an understanding by everybody that, no, there's not going to be a commission paid on this transaction. It fell apart and the money is really going back to the buyer, or some of it may be going to the seller if that was negotiated, but it's generally not going to the agents, because no one's getting paid a commission on a transaction that didn't close for whatever reason. I always feel bad for the agents, because usually it's got nothing to do with them. They did their job, they as agents, and something happened to the buyer or the seller, and they couldn't close for whatever reason. So they don't get their commissions paid from that too.
Well, trust money is never really our money, right? I don't look at it that it's our money in any sort of respect. Trust money really belongs to the client, and that's really how we deal with it, and we safeguard it and hold it in the highest regard.
Right. And it's only upon successful completion of the transaction that monies get dispersed to pay outstanding commissions. And that's right in the body of the agreement of purchase and sale. Okay. The interesting thing about these, you refer to these documents as a mutual release, and parties have to be careful when they're signing a mutual release, because the direction part might be clear to everybody. They want the money, it all goes back to the buyer, or some goes to the buyer, some might go to the seller or whatever. But the release language in there is important to take a look at from a legal point of view, because the general language in those printed form mutual release is that it's a full release of everybody, of all obligations, etc. So even though the seller might intend to just give the deposit monies back to the buyer or some of it, they may not really want to be releasing that buyer from all other damages, because they got to put the property back on the market and sell to somebody else, and they want to reserve those rights to sue for damages. So that can be done in a release as well, but the language has to be changed, that we're releasing not the parties complete from the transaction, we're releasing the deposit monies. This is how it's being dispersed, but it's without prejudice to a seller's rights to sue that buyer for other damages that might be incurred. So sometimes that's when you got to bring us in on these terminated transactions to just check the wording on these release documents.
Absolutely. And you know what, that's an excellent point. And we often do, just because if there's any issues whatsoever, and if one of the parties is contemplating, any sort of actions or claims, then a mutual release is not the right form to use to release the money from the trust account. And this is where, our relationship is so important, and we lean on your guidance and support just to make sure that we give the right guidance to our clients. But to a lot of agents out there, this is really, really important, because once you sign a mutual release, that's all there is. All parties walk away, shake hands, and no party really has any recourse or any rights to any claims. And if one party does start a claim, then I believe the language in the mutual release is that it actually indemnifies the other party. Or David, what would happen in that case if one party signed a mutual release and started a claim against the other party after everybody signed the mutual release?
Yeah, the defense, the first line of defense to that claim would be, they hold up, here's the mutual release that you signed, you released us, so we're out, you can't sue us. But you're right, there's also some indemnity language that they, until they get in front of a judge, or the cost of getting in front of a judge who's going to look at it and then throw it out.
Yeah.
There's indemnity language that they can recover those costs against the party that's pursuing a claim when there was already a release given.
Right. That would be the easiest court case in front of a judge, I think.
Right.
But I mean, a lot of the times, listen, a litigation lawyer is also going to look at the facts and examine the facts and give their client advice at that point that, listen, I can take your retainer, but your probability of success here is so minuscule, just because you signed your rights away. There's a release here, the other party's going to lean on this release, and there's really nothing out of context here to say that this release was signed out of duress or anything like that to really make a case out of this.
Right. Like, did they have legal counsel before they signed the release? Was it on the advice of legal counsel, so they understood exactly what the release was saying? Did they understand that it was a full and final release of everything and they gave up the rights to sue? Or did it still allow them to have rights to sue? And was it explained to them? So there's those type of things that those issues come up and everything. And just also to the point we were talking about last week a little bit, when we were talking about, duty to act in good faith and those type of principles, those all come into play as well on these cases that do go through the courts when they're deciding on, whether deposits can be kept in full or whether there's additional damages and the extent of that. They look at all those factors as well, where the party is always acting in good faith, was the non-defaulting party acting in good faith, and give them an opportunity to extend or offer them reasonable terms of an extension before they just pulled the plug on the transaction and relied on their legal principles. And look unkindly to people that don't come into court with clean hands, is the concept in quotation marks, right? You can't just say, oh, they're in default, I can do whatever the hell I want. And no, you have to still comply with your side of the agreement, and you still have to act in good faith and be reasonable. And I think once we see a round of litigation go through during the COVID year, that'll become even more into play. Because I think a judge is just going to hammer any party that just tried, that didn't act in good faith and didn't try at least to come to some reasonable terms to extend a transaction or keep it going or find a way to close it, before they just pulled the plug and said, no, I'm keeping all your deposit and I'm going to sue you.
And we saw a lot of this going on in 2017 when the market cooled off, right? And a lot of buyers said, oh, I'm not closing on this transaction. I'm just going to walk away, take me to court, right? And kind of hoping that, or leaning on the fact that a lot of sellers won't. And what we saw is we actually saw a lot of people go through the court system. And David, I'm sure you can shed some light on this, but from my understanding, the court system came down extremely hard on those buyers who didn't act in good faith and who arbitrarily made decisions not to go through with some of the transactions because they felt they overpaid because of the market shift now, right?
Yeah. And the courts are really looking to figure that out. And if they really felt that a party was not acting in good faith and just saying, oh, this is an easy way, not an easy way, they're still costing some money, but I'm going to walk away. Sometimes that's not enough. So the courts are looking at what market conditions were like at the time. That's a very important factor. They need the evidence, from the agents produced in a court proceeding as to what market conditions were like. And what would a reasonable buyer, reasonable seller expect for it to go back on the market at that time? And if parties didn't act in good faith or just showed, oh no, I'm just going to walk away and I'm not likely to be sued for damages, the courts are bending over backwards the other way. And that was, like you said, it's 2017 when that was going on. So COVID is only going to reinforce those type of positions, because the judges are going to be a little more sympathetic. They're always going to want to protect the non-defaulting party and try and keep them whole, but they don't want that party to take advantage of a situation either and look for windfalls and get unreasonable amounts. They want to make sure that they're covered for their reasonable expenses and their costs, and sometimes that's extensive, but they want to draw a line somewhere and look at the equitable principles.
Right. So if we switch gears, David, and talk about a seller, right? And let's say a seller changes their mind on selling a property. And I'll give you an example of, a little old grandmother, grew up in a house for 40 years and she has a big yard, beautiful white picket fence. And closing day comes and she just says, you know what, I have too many memories in this house and I'm not ready to let it go.
Mm-hmm. Right, which is sort of the cold feet by a seller. And who wouldn't have sympathy for that little old grandma? But on the other hand, she signed an agreement of purchase and sale. She signed a contract. Time is of the essence. She's got an obligation to close on the closing day. You can't just change your mind. There's consequences to doing that. Now, one of the remedies that could be available to a buyer is for specific performance. For a buyer to say, I'm ready to close. I've done everything. I've got my money. I've got all my stuff together, signed all my docs. I'm ready to close. I want that property. You agreed to sell me that property. So if you don't, I'm going to go to court and get a judge to order that you sell me that property and make you fulfill that agreement. Unfortunately, the remedy of specific performance is hard to obtain unless the buyer can show that there's something really unique about that property that made that
cannot be replaced.
It cannot be replaced. They can't just go down the street and buy a similar house at a similar price. There's something about that property that was unique, especially to that buyer. Okay, that's a hard thing to establish, and the courts are reluctant to give that without some pretty compelling evidence as to what made that unique. Because what the court says, look, I can't force them to give you that house, but I can force that grandmother to compensate you in damages for any other costs you incurred because of their default. So you as a buyer, if you have to go out and buy a similar property, because there was nothing unique about that property, go find another property that was similar. And if that similar property costs you more money because the market changed and you have to spend another $100,000 to get a similar house to the grandmother's, then that grandmother, we can make an order. The grandmother has to pay you that $100,000 for the difference in price. And you incurred legal costs and you incurred other damages. So they can award that. So the judges would say, if the buyer can be compensated in damages by the seller, we won't necessarily order specific performance because we can make that buyer whole. So we're still punishing the grandmother. She gets to keep her house, but it's going to cost her money that she's going to have to pay that buyer because the buyer's got to find another property. Unfortunately, you got to sue to do that, and you got to go through a court system to do that. So there aren't a lot of those type of cases that happen. It's always a great discussion when you come across one of those things, because it's not that often that a seller, for those type of reasons, gets cold feet and decides not to go ahead. But it happens sometimes. Sometimes sellers just try and get out because right after the ink's dried on the offer they accepted, they find out there's another offer offering more money. So they're just desperately looking for a way to not close with one seller so they can sell to somebody else.
I think after, and I've been on those sides of the coin, and I think after, you speak or the seller speaks to their lawyer and a litigation lawyer, I think they very quickly change their mind and realize that, they do have to perform with the contract that's signed. I wasn't aware that if a seller terminates or doesn't perform their duties in their contract, and a buyer buys a different property, the seller would be obligated in a similar manner that a buyer would be obligated if a seller took a lesser price, that a seller would need to compensate the buyer. So that's actually really good to know.
Yeah, if those are real damages incurred. Again, it's going to rely on the evidence of the real estate agents involved as to, was that a fair market price under the original contract? And you're comparing another property, and how similar is it? Is it comparable? And what's the difference? But if there's a real difference and you can establish to a judge that you couldn't have done any better, you couldn't have bought another similar house for a more reasonable amount than that, and you can establish that, then you're entitled to claim that and recover that against the defaulting seller.
Yeah, no, absolutely. The one positive thing if a seller defaults is that there's also a house, and if you go through the court system and get a judgment, you can also register the judgment against the property. So I mean, you're protected by the real estate involved as well.
Right. So, and you need a litigation lawyer that's going to be able to act quickly and get an order quickly. You want to be able to get something registered on title to make sure that house isn't sold to somebody else before you get rights to, because you want some security to know they're going to get paid if they're successful in their litigation. And that creates a whole other issue, because you can't always, tie up a property that way. So you've got to go to court. It's always unfortunate when someone has to, my litigation friends hate me for saying things like this, but it's always unfortunate when you have to hire a litigation lawyer and get one involved, because it's expensive. You got to lay the money out up front. Even if you're in the right, you still got to pay your lawyer a fair bit of money up front to get them going. And if they have to go to court on a rush basis, it's a very expensive process to get an injunction or that type of relief.
It is, and you know what? I think it's just sitting here thinking about the numbers and the volume of transaction that my office does, compared to how many litigation cases there are in front of the courts involving our transactions, and I think the numbers are like 0.001%, right? And I think that's a true testament to the training that the brokerages do, and our relationship, and the fact that we are always striving to educate the realtors, and we get involved very quickly. You and I, I'm on the phone in less than 3 minutes. If I can't resolve the issue my agents get your team involved, and together we're able to really get to the root of the problems so quickly. And working together as a team, we really resolve a lot of the issues before us, and they never get to the court systems, and they never go down this path. So I think that's really, really important as well, navigating through this and just realizing that, these are all the remedies available to buyers, to sellers, that this is what happens in the court system, but just having the guidance and leadership not to even get there and to have successful closing in place, is putting a big smile on my face, because I just never really thought about this just before now having a conversation. Like, we do so many thousands of transactions, and I think I have 2 lawsuits in my brokerage right now, which is amazing. It's extraordinary how busy of a brokerage we are. We have 190 agents. We do thousands and thousands and thousands of transactions a year, and we have 2 lawsuits in front of us. And then that's a testament to our partnership and everything else that we do on a daily basis.
Yeah, and that's an excellent point, and I think it's a great testament. And similarly, in our office, like, we are literally closing a few thousand transactions every year, and we've been doing it for 40 years. And I can tell you, right now, the 5 lawyers in our office right now, we don't have a single lawsuit that any of us are involved in, like not one, not a threatened lawsuit. And that's not just saying, oh, we're all great lawyers, we don't get sued, because there's always the risk. We're thinking about it all the time. But everything we're doing and the advice that we're giving, we're trying to give proper advice. But that's where I always go back to. We're also aware of the practicalities and the emphasis on trying to get transactions closed and try and find a way to get closed. And the motivation for getting it done is to avoid the lawsuits. We have to understand the law. You have to understand the law as a broker of record. You have to understand the law as a real estate agent as well, because our whole goal is to not have these lawsuits, is to get transactions closed. So I think it's a great point, David. It's great, for your firm. It's great for my firm that we're not involved and buried in litigation. Our clients aren't involved in that, because we are sensitive to what those rights of the parties are. And so we're always addressing it and trying to keep them out of the litigation, focus on getting the deals closed as opposed to suing each other and standing on legal principles.
100%. And I think there's a big educational component there that, is definitely at the forefront of that milestone.
Yep.
Awesome, David. Well, I think we're going to end it here. Believe it or not, that was a full hour of a podcast.
Wow.
Time flies when you're having fun. Thank you guys for joining us. A lot of awesome topics that we just discussed, and we're going to dive even deeper next week on podcast number 5.
Looking forward to it. Everybody have a good week. Stay safe. Get out there. There's lots of action, and do some good deals.
Awesome. Stay productive, everybody. And remember, build wealth through investing in real estate.
Welcome to David and David on Real Estate. Join us as we explore the ins and outs of the real estate market and dive deep to understand the issues affecting buyers, sellers, investors, and businesses. If you love real estate as much as we do, sit back, relax, and gain an insider's edge to the exciting world of real estate. David Gorski is a broker and the owner of Sutton Summit Realty, a powerhouse brokerage providing guidance to over 180 realtors. And David Korman is a partner at Kormans LLP, a respected law firm specializing in residential and commercial real estate transactions, with offices located in Toronto, Mississauga, and Markham.